Hi, everybody. I'm Peter Schwartz. I'm the director of the IU Center for Bioethics, and I'm pleased to be here to welcome you to our next installment of the TREATS series, the Translational Research Ethics Applied Topics. These are recorded and placed online for further reference, and it's a short introduction to an important topic in research ethics related to translational research. And we're thrilled to bring this to you. Today, we are honored and lucky to have Professor Mark Fox with us. Professor Fox is a longtime member of the Bioethics and Subject Advocacy program of the CTSI here in Indiana. And he handles much of our work up at South Bend campus of the School of Medicine and the Notre Dame campus as well. He is Associate Dean for IU School of Medicine in South Bend, and interim associate dean for IU School of Medicine in Northwest Gary. He's also professor of medicine and professor of pediatrics. For the topic today, I'll say he has a special experience to share his thoughts on. He's probably thought about the topic for our seminar today extensively as the he was the deputy health officer in St. Joseph County through the pandemic. And so he definitely thought a lot about the public health exception in research. And today he'll be talking about the public health exception, its proper use, ethical and regulatory issues as applied to it. And I can't think of a better person to do all of that. So with that extensive and unnecessary introduction, Dr. Fox.
Well, thanks for that introduction, and thanks for the opportunity to present this topic today. I hope Peter hasn't oversold it, because I feel like a lot of this is kind of me thinking out loud about some of the challenges that arose in the public health setting during my 5 years with the St. Joseph County Department of Health. So through that time, I was the deputy health officer. So I always had a boss who was the health officer who had the actual real authority. But, I guess a lot of these issues didn't necessarily arise specifically because of the pandemic, but the pandemic framed certain issues in important ways, and in some ways lended some clarity. So I want to just give a little bit of context. So I joined the St. Joseph County Health Department in 2018, so pre-COVID. And my focus really was on community health improvement initiatives. So really a lot of my work was around immunizations, infant mortality, health education and outreach, and childhood lead poisoning prevention was really, honestly, probably the single issue that created the greatest impetus for that role. There was some data that showed that there were areas in St. Joseph County with startlingly high rates of abnormal lead levels in children, and so it was a desire for the county health department to be more proactive, I think, in trying to address that. Obviously in St. Joseph County we have several higher ed institutions, but a group of investigators and faculty members from Notre Dame also were really drawn to work on the lead issue, and an interesting kind of cadre of people, from some with public health training, others with I think one is an archaeologist, and then a couple of chemists, and so really different expertise that all came together to think through some of the issues that range everywhere from the outreach and education piece to motivate parents to get their kids tested, to the finding better ways to test houses to assess their risk of constituting lead exposure for kids, and trying to make that a simpler process. So a lot of different perspectives that they brought to the issue. So we often had requests from faculty investigators to get their hands on some piece of data from the local health department. And if in Indiana, there are I think 95 different health departments, so most of them at the county level. especially in Northwest Indiana, there are several at the city level. So Gary and East Chicago have health departments that are distinct from Lake County. But so nearly 100 different, health departments across the state, all with varying levels of staffing and expertise, and almost none with sophisticated data infrastructure and resources. And St. Joseph County, even though it's one of the larger health department or one of the larger counties, was plagued by that. So actually, there was very little data that the local health department curated on its own. So a lot of the data was, gathered and available from the state rather than being collected and maintained by the health department for public health surveillance activities. But we could get lead data, and so one of the first requests that we got was, for a 10-year bucket of data related to childhood lead testing. My boss at the time declined the opportunity to enlist faculty investigators to analyze that data, and cited HIPAA privacy concerns. He kept saying that he didn't want to be tagged with a HIPAA violation in sharing PHI with investigators. And I tried to talk to him about, public health surveillance activities as an area that was permissible and with appropriate legal structures for data use agreement and business associates agreement and stuff that I certainly thought that it was navigable. The lawyer who was staffing the health department also had concerns, and so it just put a roadblock there, and those data were never shared for analysis by the investigators until later. But initially, he was not willing to share it, even though I felt like I could point to evidence in federal regulations and in HIPAA that would allow it. And it really underscored for me, one, kind of both the lack of maturity of data systems at the local health department level, but also a lack of sophistication for many local health departments about, what data can we share, who can we enlist to help us, and what constitutes public health surveillance as opposed to research, and does it matter where the impetus for this comes from? If someone outside the health department proposes a project, does that make it not a public health activity, even if it falls within this domain of public health, or seems to fall within the domain of public health surveillance? So, there are a lot of things kind of packed into that. Then the pandemic hits, and so that, honestly, that got tabled for quite a while, I would say. But it really set the stage for what were really pressing issues around data collection, data storage, data sharing, and how data gets transmitted, from the state to the local health department, or from outside entities to the health department. And so, there were some aspects of the public health emergency that basically the Office of Civil Rights said they weren't going to pursue any potential HIPAA violations in the context of the pandemic. Essentially, if there was a good faith effort to do God's work, if you will. So that took a little bit of heat off, but it clearly exposed the kind of the immaturity of the systems and even the thought process. And I suspect in Indianapolis, the relationship between Fairbanks and IU Health and Regan Streif and the state health department, that context and the conversation and the collection of expertise there probably was a very different conversation than what was happening for all the other jurisdictions in the state. So, I think it prompts a number of different questions. And if you look in kind of the old, the pre-2018, federal regulations on research, CDC and Office of Human Research Protections put out guidance that tried to differentiate. This was pre-2018, this was back in 2010, put out guidance to differentiate what is kind of public health research versus public health non-research. And actually the framework of that I thought was very helpful, and some of it sort of got imported into the 2018 and following guidance in the CFR. But it seems like there are a number of questions that really have to be addressed when you're thinking about public health data. One is, does whatever you're hoping to do, does it require IRB review? So I would suggest that there are at least 4 questions that need to be addressed. One is, does it require IRB review? 2 is it research? What does HIPAA or other privacy regulations require? And then the last one that I think almost never gets asked is, does it comport with reasonable expectations for the individuals whose data are included in whatever repository you're considering? So I think at least those 4 questions need to be addressed. And in the contemporary CFR, when it talks about research in whatever 46102, it follows the standard definition. Research means a systematic investigation designed to contribute to generalizable knowledge. And clearly a lot of what happens in public health surveillance meets that definition. It's a systematic investigation. It's often intended to contribute to generalizable knowledge, except that it has an exclusion. And in this code, it says, for purposes of this part, the following activities are deemed not to be research. And the second item in that is public health surveillance activities. And it goes on to specify, and I'll share the screen just so people can look at it. If I can share the right screen. Okay, I hope you're seeing a screen where in the middle it says number 2, public health surveillance activities. And, so it includes collection and testing of information or biospecimens conducted, supported, requested, on and on, by a public health authority. And so, in the definitions, they define a public health authority clearly at federal, state, local, tribal levels. It also extends to, in another section, it says that the public health authority can engage other individuals or entities to participate in this work. So it would, if we were to engage local faculty, for instance, we can set up a mechanism so that it extends to them. And then in the second sentence, such activities are limited to those necessary to allow a public health authority to identify, monitor, assess, or investigate potential public health signals, onsets of disease outbreaks, or conditions of public health importance. And so I go through all that because as we kind of emerge from the crisis mode of the pandemic, I guess, we had set up a mechanism in the local health department to focus on adverse childhood experiences within St. Joseph County, both to collect data at an epidemiologic level, but also to engage partners in thinking about interventions to address or mitigate the impact of adverse childhood experiences and to promote positive childhood experiences. So, part of this was a data collection effort that originated from the health department. So it was not driven by outside investigators, at least as the impetus. We did engage them, but really the research question, if you will, or the surveillance question originated from the health department. But within Indiana code, there are certain public health activities that are mandated. They have to be done. They may engage in other things. So for instance, immunizations are not mandated under Indiana code. So a local health department does not have to offer immunization services at all. And yet for many of us in public health, that's one of the arguably the single most important public health intervention that we offer. So, you know, in determining the scope of public health authority and suitable public health activities, you know, this often gets just abbreviated as public health surveillance activities. And I think we run the risk of interpreting that at either extreme, either too narrow of an interpretation. And I've also seen examples that really seem to go way too broad. And I'll try to give an example, but you know, in setting up this mechanism to investigate the prevalence of adverse childhood experiences at a more granular level in St. Joseph County. So beyond what the BRFIS reports have included over the years that's been included, which gets at the state level, not the county level. You know, it was deemed, we did consult the IRB to kind of get their blessing and say, yes, this appropriately falls within the scope of public health surveillance activities. But, you know, it's similar to the analysis that goes into exempt research. Should it be the investigator who decides, yes, this doesn't need IRB, or should someone with the imprimatur of an IRB say, we concur with your assessment that this does not require IRB review, and this falls into the category that's deemed not to be research. So, you know, in that case, I think it was perfectly reasonable. There were other situations not enacted by our local health department, but things that I became aware of through other mechanisms, and this was particularly in the setting of the pandemic. There were different jurisdictions that were evaluating different approaches to different protocols for screening asymptomatic individuals. This was in the context of, and again, this was not in our local jurisdiction. So I want to be clear about that, but it was a study done in another state for a higher ed institution that was really evaluating different approaches for screening asymptomatic individuals for COVID, and assessing the impact of that. And I think that raises an interesting question because partly it may be understood as a public health surveillance activity. They were using the same test, but in kind of a different sequence or different time frame, and evaluating the efficacy of that. But it wasn't, one could argue that it didn't constitute surveillance in the broadest sense of what's the prevalence of disease in this population, because it related to identifiable individuals. So it really became the basis for clinical decision-making rather than public health intervention. So it wasn't about quarantining a dorm or closing a classroom or something. It was, does Johnny need to go into isolation or not? And so, you know, arguably maybe that could be understood as a quality improvement or process improvement evaluation. So I think some of the questions that arise in public health research I think it may be important to ask the question of, does this affect individuals, identifiable individuals, or is it really about process? And so do we think about this as it's more akin to a clinical trial and a clinical intervention, or is this more akin to a process or quality improvement? And should our thinking about it be different? But then that's where also for the individual, you know, does consent from the individual or sharing of individually identifiable information, particularly when it relates to clinical decisions that impact the individual, we might argue that different expectations around privacy relate to how we assess that question. So, as I've thought through these issues, I think a couple things become clear to me. One is, if you try to look at public health and HIPAA, there's a lot of guidance about related to covered entities being it's permissible for covered entities to share data with public health authorities. So it's more about sharing data into a public health authority. There's not great guidance about what data public health authorities can push out, or even what the process really ought to look like, either in structuring public health research activities and privacy concerns there and data sharing concerns there. It's much more about data coming in. Again, I think a lot of these are navigable, but it's just much harder to tease out the guidance. I wonder also if one question relates to whether data already exists. So for instance, in the case of analyzing the lead data, that's data that was already collected for other purposes. So again, it resembles, in terms of exempt research, it resembles secondary analysis of data collected for clinical purposes. And yet, should the determining factor be, how do you intend to use this data? If it's for, broad descriptive epidemiologic purposes, one, you could probably get away with de-identified data or a limited data set. But if it's to follow up on Johnny, Johnny didn't get his subsequent lead testing and needs follow-up, then if the intent, primary or a secondary intent, is for intervention at, an individually identifiable level, does that change how we ought to think about it? Not necessarily from a research IRB question, but from a privacy and data sharing question. The other is, I think that we run into a couple of kind of counterintuitive counter examples with respect to public health data. And again, I'll give two examples. One is, within the federal bureaucracy, we have certain requirements around lead testing that come through centers from CMS, through Medicaid, requirement to test children at ages 1 and 2 for their lead levels. And in Indiana now, that's been expanded beyond Medicaid, and ostensibly providers have to demonstrate that children have been tested at age 1 and 2. So there's an expectation that that's been done. And HUD has certain programming for lead remediation, and they fund grants to different entities or local jurisdictions to promote and facilitate lead remediation. Again, many local health departments are reluctant to share PHI with, the housing authority or whoever runs a HUD grant for lead remediation because it contains individually identifiable information. Office of Civil Rights has issued an opinion that the health department can share PHI, individually identifiable information about children with abnormal lead levels to HUD-funded entities to promote this activity. So to engage specifically with identifiable families to try to engage them in lead remediation funded through HUD. So the full rationale for that is not entirely clear, but again, for clinicians, we have a knee-jerk reaction that says, no, of course I can't share this PHI with, the housing office or the code enforcement or whoever is managing neighborhood development, who's managing this HUD grant. Well-intentioned, hopefully there's benefit from it, but there's a knee-jerk reaction against it. On the other hand, when you think about HIPAA and FERPA and childhood immunization data, the local health department cannot get data from school districts at an individual level that Johnny is deficient in these immunizations without explicit parental authority. Because when the immunizations are shared with the immunization records are shared with the school district, they become FERPA records. They're not clinical records. And the legal opinion at the federal level is that educational records can't cross over into the clinical venue without explicit authority, even though that's a public health activity, again, akin to, I would argue, I would certainly argue that it's no more needing privacy protections and considerations than sharing lead data with the HUD grant recipient at the individual level. And so we have these, counterintuitive examples, and I largely think it relates to a lack of clarity around public health research and surveillance activities, data sharing and privacy, especially at the individual level, that plagues a lot of the conversation. And again, in very sophisticated settings, it might not be an issue, but for 92 counties across the state of Indiana, it's probably an issue in 90 of them anyway. So I mean, I'll stop there, and certainly people who either have a lot more experience or insight into this or can teach me everything I need to know about this, I would welcome the clarity. And other than that, I would just welcome conversation to see if any of this resonates or if your experience looks or feels very different. Thanks very much for the opportunity to at least to introduce the topic.
Well, that's great. I'm going to use first name. So Mark, that's great. I'll let others ask. I have about 5 questions, but if I start, then nobody will get a chance. So let me give a minute here for anybody who might want to hop in with either a question of clarification or a comment, anything you'd like. Well, in the absence of somebody else taking the lead, let me go ahead and get started. I'll ask some questions. I think we may get some discussion around some of these questions. So first, Mark, I was in a meeting recently where they were talking about public health data. I think I mentioned this to you when we spoke before this talk, where somebody said, well, basically the bottom line is doing research with the public health exception. Do you basically have to be a person in a public health department the way you were when you were deputy health officer in your county? Like if Peter Schwartz wants to do something which falls under that thing, you're still sharing the screen, which I'm glad, the public health surveillance activities, I basically don't count, right? Unless I'm in the public health department. And is that right? Like that's basically a bottom line take home message we should know, that Peter Schwartz, without an appointment in public health, cannot conduct a study under the public health exception at all, or is that wrong?
Well, so here I moved up to this section in the definitions. defining public health authority. So agency or authority of the United States, state, territory, political subdivision, Indian tribe, etc., or a person or entity acting under a grant of authority from or contract with such public agency. And so this is where, one of the questions I raise is, does it matter where the impetus for an inquiry comes from? If Peter Schwartz comes to me as the health officer and says, I want to look at data on whatever, it's a little bit like, I might argue it's a little bit like a letter of support in the IRB that, we agreed to collaborate on the question started with you, but we agree that it's a matter of importance to the health department. And so then we extend that authority to you. We contract for it with a data use agreement and a BAA or whatever.
Yeah.
And then you're acting on our behalf, or at least in concurrence with us. And then what does that mean in terms of who owns the results or what can be done with it? I don't think that necessarily precludes publication or anything for your academic trajectory. And again, this is where I think analyzing the lead surveillance data, the Notre Dame investigators just had more bandwidth to do it than we had certainly at the time within the Department of Health. And so it seemed straightforward to me that, even though the initial inquiry request for the data came from them, that it was in line with the mission of the Department of Health. It advanced the work of the Department of Health to have that analysis. And so that ought to be navigable.
Got it. So I'm sorry. Yeah, that was your example. Actually, I guess I hadn't gotten the sense that it had gone forward. So an outsider researcher comes to you as a public health officer, others in your office, and say, we want to do this study of lead. You agree that there's a public health implication under that one that was up here before, the number 2, that it's a matter of importance, a matter of potential action for public health. And then when the advantage to them is that they can conduct the research on the public health exception. And the questions, is that right?
Yeah.
Or maybe funded, or there could be a collaboration there.
Right.
Yeah.
So, a lot of times I think the workaround, again, depending on the intent of the research or the nature of the question, the workaround has been to share de-identified data or a limited data set. But, as I understand this, there would be nothing to preclude sharing, a complete data set with all identifiers with the appropriate safeguards in terms of data use agreement, expectations around no sharing beyond that, that investigative team, and protection against disclosures. And then that's where institutional lawyers are interested in indemnification and everything else. So.
Okay, let me be quiet for a minute here, see if anybody else wants to hop in. I have some other questions, but I'll hold back for a second.
I had a question.
Yeah, Nick.
So from the screen you were showing earlier, there was a section about law enforcement using public health data records and biospecimens. And I was curious if you knew anything or you could speak more to that usage.
So number 3 there on the screen, collection analysis of information biospecimens for criminal justice agency for activities authorized by law or court order. So one thing in a lot of the guidance around HIPAA, I mentioned before that there's guidance about what a covered entity can share with a public health authority, and without individual authorization. And that's pretty clear. And among the disclosures from public health authorities and other covered entities are disclosures around, for instance, child abuse, And so there are some clearly identified categories for disclosures that relate to that. I think, so as far as research, it's an interest. I don't know how that would again get interpreted. So you can analyze, information and biospecimens for a criminal justice agency. I assume a criminal justice agency, just like a public health authority, could extend that or could engage, faculty researchers to assist in that work and everything. One of the things that comes up, I think there's a lot that happens, and I don't know if this has ever been addressed in a Treats talk or any other bioethics forum, Peter, but there's a lot that happens in hospital emergency rooms under the authority of local police that probably goes far beyond what the actual legal authority is in many cases. And the dance around that can be really tricky, I think.
Yeah, let me help. I think this list 1 through 4, Nick, and other people watch, I'm glad you asked, Nick. These are the 4 specified areas where something that looks like research should not be considered research by an IRB or by an ethicist for that matter, right? So actually, we were focusing on number 2 because that's a case where public health surveillance is being given this exception, the subject of today's talk. It's not to be counted as research, even though it is basically the systematic generation of knowledge, right, for generalized use. And so this is why it's an interesting exception, which one might want to use in one's research ethically and for regulatory purposes. 1, 3, and 4 on this list are other areas, including the criminal justice one you raised, Nick, of where even though it's a systematic collection of information for generalized knowledge, it is exempted from the common rule, from being treated like research for purposes of research ethics or regulation. And so that's why the legal thing there is. Now, Mark did talk about whether you can release public health information to a legal authority, or say you can release like institutional health data to a legal authority, and when that is. I guess we're probably not going to solve that one today. That's really important legal questions. But that's why this list is very interesting for those of us who think about what is research, what is not research, and what ethical principles apply. Because the ethical principles sort of migrate when you're moving into the research realm, as well as the regulatory thing. So that's a good question, Nick. I appreciated that. I was going to ask push a little bit more also to go on after next question with the question about, you said it's a question about bringing data in, which is sort of the public health exception. It's to make this research sort of, or this project, the Notre Dame researchers might do in collaboration with the public health authority, or which public health authority might do, say, with COVID testing, where it won't count as research for purposes of an IRB or research ethics. But then there's a question of giving it out. And I guess here's my question about giving it out. And in the public health realm, maybe you had this. You have data. Researchers want to get their hands on that data. Maybe it was collected for a public health purpose. Can you release it? And I guess you were saying the identifiable data, there are these complexities of when and if you can release it. I guess the HUD thing you mentioned, where you can release identifiable data to HUD, even though it's collected for public health surveillance, you can, because you're giving it to HUD, I assume, because they like have a subsidized housing which has a horrible lead problem. You sort of want to tell them, not just in general, there's problems in the state, but you want to tell them this address, right, is returning all this lead information. We're going to tell you something identifiable. People here are getting high levels of lead. Go fix your building, right? Isn't that sort of the idea of the HUD release? But maybe it's a first or second. But then the other question is, with de-identified information, is that also a question? Like, it seems like if it's de-identified, it should be given away as needed, right, as to researchers as needed. But apparently that's not the case from what I've been hearing from other venues. So those are my 2 questions, Mark. I'm sorry.
Yeah, so just to be clear on the guidance about sharing data from a public health authority with, it's really a HUD grantee. So for instance, here locally, the city of South Bend is the recipient of a grant from HUD to fund lead remediation in properties that have that contain lead, and have housed individuals who ultimately had abnormal lead levels. So there had to have been kind of injury associated with it, I think, in at least in one of the grants that was true. So, and from either an ethical or a legal standpoint, the justification for releasing clinical or public health identifiable clinical or public health data to another entity, I don't think was really clear. They just said, yes, you can do this. And whether it's because it's funded through another federal agency, so this wasn't research related, this was a privacy concern, but it was deemed that would not be adjudicated as a HIPAA violation. And yet it doesn't seem to fall in any of the conventional categories of disclosure. It's not child abuse, so that's one of the authorized disclosures, right? So the rationale for that, but not for a similar disclosure from a school district around immunization data, seems nonsensical to me. There was a second part of your question.
Yeah, to de-identified data, is it possible to release that? Is that a big barrier for a public health authority to have data they've collected or collected with collaborators to de-identify that data and release it? Or is that still is that very difficult?
So, at face value, it ought to be fairly straightforward. The challenge of, who does the de-identification, because that can be labor intensive to do well. So there's some burden associated with that, which just makes it a non-starter a lot of times. The other thing, and I meant to mention this earlier, there are also a few, again, counterintuitive aspects that are written in Indiana into the state statutes, for instance, around the cancer registry. So the local health department can't get granular data, down to like the census tract level out of the cancer registry, because the state statute that established the cancer registry doesn't allow those disclosures, even though it's still a public health activity. Why, in their infinite wisdom, the Indiana legislature felt it necessary to constrain that is one of the great mysteries. But, when we tried to get much more granular level data on cancer screening and things, it was not allowed under Indiana statute that established.
Again, these are barriers. I'm just going to make a little pitch here, a little call to action for the world that obviously linking these data sets, making them available for important work is really important activity. Both the regulatory world to get over these legal barriers, finding the ways to define the law maybe more clearly and really use this data for public good without these kind of barriers. Again, I've been hearing more and more at the national level about even large national agencies unable to collect important data on comparative effectiveness research that's carried out locally, and also public health data. Obviously, you probably faced that with your COVID testing activities as well, to access data files that could be helpful to you. But you mentioned in passing, I won't lead you back to the 4 questions. We're going to put those in the intro to your talk. Maybe a little sentence about each, just people can see what you were talking about here. But one of them was about whether people sort of had a reasonable expectation, whether you're operating within the reasonable expectation of people who allow the data to be collected. I think that's a really interesting question, and how to address that's really interesting. So,
I think the HUD lead example is, to me, is a great question. Again, that wasn't prompted by a research question, but do parents have a reasonable expectation of privacy that the City of South Bend lead remediation HUD grant operators shouldn't know that, you know, that Johnny had an elevated lead level. They, you know, in the normal scheme of things, there would be no other reason why they should know that. You know, so is it a property level disclosure? If it's about a property, is that different than it's about Johnny? Someone at this address, or this address is known to contain high lead levels. You know, so I think as a parent, I would think that at least my child, on behalf of my child, I have a reasonable expectation of privacy that, you know, some non-clinical person shouldn't know my child's lab result. And is it ultimately a semantic thing, or that the disclosure can be made about a property? Someone at this property had an elevated lead level. And, you know, the guidance really doesn't speak to that. But whether it comports with the expectations of a reasonable person related to privacy of clinical or public health data, I think is a question that ought to be addressed.
Yeah.
That's why I think it's important to sort out okay, so you say it's not research. The federal regulation says it's not research, and yet HIPAA and privacy considerations still may matter, especially to the individuals included. You know, one of the cases where this came up, we were actually working with some researchers around a data sharing agreement, had a different lawyer at the health department who said, well, you know, if there's any citizen of the UK represented in this data set, then all of their privacy expectations apply. And, you know, unless you can assure that there's no citizen of the UK included in this, or unless you can assure that you're compliant with all of their expectations, then we can't share this data.
And de-identified way, even.
That was with any identifier. That was around a limited data set.
Okay, well, we're getting in the weeds here, and I'll probably continue this conversation with you. Where we're doing some public work. You probably, as you know, in the spring with lay people on collection of information and data, especially part of biobank research. But
Right.
I think there's some interesting questions you've raised here that really we should really put to some of these lay people who were enrolling. So, okay, that's it for me. Anybody else questions for Dr. Fox while you've got him? Okay, we'll tell everybody, Mark, for people to email you directly as they consider using the public health exception or want to get data from a public health authority. I see Karen's come up. Has the conference room come off mute?
No, just wanted to confirm our room is quiet here with questions. That's it.
Great.
Right.
Thanks,
Well,
everybody. Oh, good.
I was just saying, thank you all for your attention, and thanks for coming.
Thanks for being here, Mark. Take care. See you all.
Bye.
Bye.